Good afternoon, or still good morning, isn't it? It's just 2 minutes to midday, so good morning, everyone. Welcome along to our weekly webinars. We're expecting a lot of people today again, so we'll just give people a chance to tune in. So you just bear with us. We're pouring in, Chris, this morning. You must be a popular person.
Of course. Yeah.
Yes. We normally leave it until just a minute or two after midday to give folks a chance to sign in, because I don't know, like me, with these Zoom and team meetings, I tend to skid in at the appropriate time, moving from one Zoom meeting to another Teams meeting. So we'll just give people a chance to sign in. Mohammed says good morning, and good morning to you, sir, as well. If you would like to maybe just let us know who you are, your business, your organisation, where you're from in the chat box. That's always a nice thing to know where you're tuning in from today. We've got hosts now from all over the UK, so we could be anywhere, which is great to know that this Friday lunchtime webinars audience is growing. Daniel Cantrell from Dorchester. That must be down your way, Chris.
Yeah, not far.
Mark Vines from Pembrokeshire. Hello to you. Joe and Gabriella from Llewellyn Harker Low Architects. Darren Queenham from Somerset, my home county. Irian Jones from Ceredigion County Council. I probably haven't pronounced that right. Anthony Dawson, hello to you. So, they're coming in. Probably the names are coming in now too quickly for me to register. So it's exactly 12 o'clock. I'll give it till a minute past, and then we'll make a start, because the numbers are pouring in already, which is great. Sven Wright, hello to you. Fiona Smith from Bath, hello to you. I'm taking this saying hi to all the delegates from a webinar I attended in the States, where they really do give big shout outs. They make a hell of a fuss. I think I can quite go that far. I can have a good go, but there we are. Well, look, it is a minute past, and we've got about 80 people on board already, so we'll make a start. So good afternoon. Welcome to the weekly webinar from what was originally Constructing Excellence Southwest Midlands and the Structural Timber Association, all of whom I'm chief executive. But I've been joined now by the complete Constructing Excellence network from across the UK, all the regions, and the national organisation, which is great, and also the CIOB in the Southwest. So there's a whole band of organisations now teaming up to bring you these Friday webinars, and I'm delighted that very shortly I'm going to be introducing Chris Reeves, who's a friend of mine for several years, working with CE Circles. But before I introduce Chris, I'm going to hand over to Howard from Leaders Meets, who's going to take us through the house rules. Thank you, Howard.
Thank you, Andrew. Good afternoon to everyone. Just to let you know, we're going to be using Slido today. For those of you who've been in recent webinars, we're going to be using it today from the moment we start. So on the right-hand side of your screen, you will find two ways to get into Slido. If you want to use your mobile phone and your QR reader, just please scan that, or you can go to slido.com, and then once you're in, just enter the code hashtag LM120221, which is today's date. We're going to be using Slido today from the start by running a poll, which is essentially, from Chris's perspective, getting some indication of the knowledge in the room. We're also going to be using it for Q&A. So whilst please use the chat pane to chat to each other, it would be really good if you could use Slido for Q&A. You'll be able to look at all the questions that people are asking, and you'll be able to rate those as well. If you do have any questions, as I'll repeat, please do use Q&A in Slido. Then we all have it in one place. So what I'm going to do now is we'll open up the poll and we'll quickly run through it. So if you've got your screen fired up, it should now be coming up on your screen, hopefully. And you'll be able to go through. So knowledge of contract administration, if you could score that 1 to 10, what your knowledge is. I have to say mine's not great. So I expect if I was to fill the poll in, which I'll do, I'll have to go middle of the area. So next question, please. How many of you have acted in the role of contract administration? Now we've got about nearly 100 in the room, so hopefully we can get at least half of the people to respond, which will give us a very good knowledge of what's in the room. The next question, please. At what stage do you find most challenging? Before commencement? It's all there for you to have a look at. Now we have the next question, which is an open question. So what role do you find the most challenging? Now, the next question is, how many of you have experience of adjudication, arbitration, or court proceedings? An interesting question I would be, how many people have actually been in a witness box and how many people have actually been in front of a judge? Quite an intimidating sort of experience, that. So if you'd like to let us have your answers, that'd be great. As you can see at the top right-hand side, we've got 33 people who've currently completed it. It's now gone up to 50, so 51. So we'll give you just a little bit more time, and then we'll run through your answers so that Chris gets an indication of the knowledge in the room. Oh, we're doing really well today. Got up to 63. Seems to have stopped at around that number. Doesn't matter, it will still carry on whilst we give the feedback. You'll just find things that move. So Abraham, can we please move to the results? Interesting. If we look at 5.8, given a score out of 10, about just under 60% of people in the room have knowledge. So there's 40% here to get some knowledge, Chris. So that's a good start for you.
Mm-hmm.
The next question. Oh, right. So a number of people in the room have acted in this role, but almost a third have not. So no doubt, Chris, this is going to be an interesting session for a lot of people to learn. Next question, please. Here we go. Chris, you might want to take a little bit of note of this one. What stage is the most challenging? 40% find before commencement and after issuing the final certificate. Next question, which is the open one. So Chris, we'll go slowly through this so you can pick up people's feedback. We'll scroll through in a minute.
Mm.
So scroll through a little bit more, Abraham. I like the one people trying to be clever. That makes a living for lawyers.
Yeah.
Oh, it's a really good spread of stuff here.
Clients, lawyers, yeah.
Dealing with clients, lawyers, yeah, well.
Looking for extras, yeah.
Yeah, looking for extras, I like it. Dispute resolution, well, there we go.
It's really helpful. Yeah.
Well, 42 people in the room answered that question, so that's 40% or so. Isn't it? Last one's an interesting one, keeping to the program. I think there's one. Is there one more question there, Abraham, or is that it? Yeah.
Oh, that's high.
That's actually quite worrying, isn't it? Because it means that most people end up in some form of dispute and having to try and resolve that, Chris. So
That's high.
is that higher than you would expect?
Yeah.
Okay, so 72 people answered that one. So that's a very high percentage. Good response. So I'd like to thank everyone for that. And I'm now going to pass back to Andrew. Over to you, Andrew.
Thank you, Howard. Thank you. As you say, very interesting results, and hopefully something, Chris, that gives you a bit of a basis for what you're about to talk about. So
Yeah.
I'm just going to introduce Chris in a few sentences. Chris is a member of Constructing Excellence Southwest and has been since we relaunched about 8 years ago. He's also been instrumental in acting as author for a couple of our best practice guides, one on mediation and one on off-site legal guide for off-site. Qualified as a solicitor in 2001 and has dual qualification as a fellow of the Chartered Institute of Building. He's also a practicing adjudicator and mediator. He launched his own construction law practice with his team just as Boris announced lockdown in March of last year. And he actually took part in the very first High Court trial on Zoom in Bristol last year, which he's pleased to report went very well, particularly from the client perspective. But he will be saying a little bit more about that. So talking about navigating contracts, I'm going to turn my camera and my mute button on and hand over to you, Chris. The floor is yours. Thank you.
Thank you very much. Let me get the screen share to work properly. Right, so can everyone see the slide? Has that worked?
I can see it, Chris. Absolutely super for me. So
Yeah,
carry
that's
on,
good,
please.
is it? Right, okay. Well, anyway, thanks. Thank you for joining. I was the one that put the questions together for the poll, and I think that was a really useful exercise. 85% of people have experienced some form of dispute resolution. That's much higher than I was expecting. But experience of litigation or adjudication can be varied, either as someone supporting a party or even giving witness evidence or even being a party yourself. So, but nonetheless, 85% is a very high number. Hopefully with some of my tips, we could try and bring that down a bit. Or you never know, might even go the other way. As you spotted, I've got a bit of a croaky voice, so you have to bear with me on that. But I'll be making my slides available after the talk for those that are interested. So the first thing is my role is very much as dispute resolution specialist, emphasizing more on resolution than dispute. Those that know me know that I'm a big fan of the mediation process. And something that struck me when preparing for this is that the role of contract administration is very much acting as a mediator. And I'll touch more on why I reached that conclusion a bit later on. But I've always seen the contract administrator as the person in the middle, trying to mediate all the parties, particularly the employer and the building contractor, on the way the contracts run, payments, quality, and time, all very challenging. So very much I look at contract administration as a role for a mediator, definitely. I also get involved with putting together contract documents, appointment documents. I'll talk about the desirability of amendments to standard forms a bit later on. And we also offer general support to everyone across the industry. People like to phone or email, what does Chris think, or can we have a view on that? And it's very nice to be part of the team when we get that opportunity. So what are we going to cover? We've got, obviously we're dealing with contract administration. I'm going to touch on the differences between traditional forms of contract in design and build, issue for contract administration, appointment documents, how we can get the relationship formalized with our clients in terms of the services that you're actually going to perform. Inevitably, we're going to touch on COVID, and then we'll have some questions at the end. The usual disclaimer: this is all about guidance and not specific advice. Just important to point that out. Right. So the first slide, I'm not sure whether you can see the detail of that too well. This is the old RIBA plan of work before it was updated in 2013. Those of you that are architects will be familiar with the way that the various stages of the project have been broken down into the component parts, starting with appraisal of the project, concept, then into hopefully completion of the design, pre-construction, and then construction itself, and then the use of the building. Now, I want to just spend a bit of time looking at where contract administration fits in to the old plan of work, because we have seen a change with the new plan of work, and with the introduction of design and build, where we don't get a contract administrator. Has the role of contract administrator been diluted in terms of the tasks, in terms of the relevant, the particular stages? So the first, under the old plan of work, we had stage K. So stage K assumed that the project was going to be built on a traditional basis. And what by that I mean the employer's design team, not the contractors, but the employer's design team, were going to produce the design documents, the drawings, and specification. And the contract administrator had to manage that, the delivery of that, through to completion. Now, the plan of work says, and I hope you can see that under stage K, administration of the building contract up to practical completion. And quite neatly, post-practical completion, it continues with administration of the building contract after practical completion and making final inspections. Now, you'll be familiar with how the JCT nominates the contract administrator, but I think one point I've come to sort of notice, particularly from architects that have sought some advice about fees and charging extra fees with managing defects, is you need to make sure that if you're going to have a fee scale, a fee arrangement that's linked to stages, and you're managing defects, you're going to have to include stage L, because if you haven't included stage L, then the contract administrator isn't going to be employed to manage defects and then issue the final certificate. So as I said, as a recap, administration of the building contract to practical completion, an administrator of the building contract after practical completion. So why didn't we keep that? Why didn't we keep that procedure? The new plan of work, I think, had to reflect that there's a big growth in design and build. And under design and build, we move away from the idea that the employer's team are going to complete all the design and all the specification before we even start on site. We now have roles of employer's agents. So does that mean that we've lost contract administration completely? Well, the answer is no, because we still have standard forms of building contract. I don't know what your experience is, but in my experience, it's an extremely, or becoming an extremely popular form of contract. It's still a standard form. It's not design and build. An architect or a surveyor is appointed as the contract administrator. And you'll find under this form of contract that we'll also have the appointment of the QS. Now, the QS isn't the contract administrator. Commonly, it might be the same person, but the QS role is very, very distinct, and will have different roles under this form of contract than the contract administrator itself. Just touching on design and build as a comparison, here we see the JCT 2016 form. No contract administrator. We have an employer's agent. And we don't have a QS. Now, commonly, the employer's agent is going to be the quantity surveyor, but not always. So why is this important? Well, it's important because under the traditional form of contract, the authority of the contract administrator doesn't come from the employer, it comes from the contract. So the contract terms give the contract administrator jurisdiction, if you like, in terms of performing their various functions. Whereas under design and build, the authority comes from the employer. Big difference. Why is that? Well, interestingly, going back to the questions at the beginning of the poll, one question was, what role do you find most challenging? If you read this is a comment made by a judge in explaining what role the contract administrator's got. So the employer and the contractor make their contract on the understanding that in all matters where the architect brackets the contract administrator, they'll act in a fair and unbiased manner in applying the terms of the contract. So challenging, I think this is the biggest challenge. I think the biggest challenge is for the contract administrator to not only act in a fair and unbiased manner, but to be seen to be doing so. This is the new plan of work. So just going back to that, we can find the bits of contract administrating in stage 5. We've got inspecting the construction quality. That's contract administration. Monitoring progress against the program. Well, that's interesting because often the program isn't a contract document. So will the contract administrator be concerned with monitoring progress? Well, the answer is, of course, yes, because a contract administrator will want to be making sure that the works are progressing towards that magical date for practical completion. Resolving site queries is required. Is that the role of a contract administrator? Well, day to day, absolutely. And still within stage 5, we've got practical completion, including the defects list. Defects list, that's something that's done at the end of the rectification period, isn't it? Not on practical completion. question for you, whether the defects list is actually part of stage 5. Because in stage 6, which is handover, we've got in here, we've got rectifying defects. Well, that's a bit cart and horse, isn't it? I think the defects list and rectifying defects is probably all really part of stage 6. The point again, though, and obviously final certificate, excuse me, is part of the end of the project, the role. The point I want to make is that if you're putting together a scope of services and you're going to be dealing with a traditional form of contract where you're expected to manage defects and issue the final certificate, you've got to include stage 6. Okay, I can't look at every single task that a contract administrator has to grapple with. So what I thought I'd do would, I thought I'd pick a couple that often throw up some traps for the unwary, if you like. So a contract administrator would be expected to hold site meetings and chair site meetings. But are site meetings the same as site visits? The answer is no. A site visit to me is something that the contract administrator does as part of inspecting the work. Site meetings are more about managing members of the construction team, and they have to be kept very different because they serve 2 different purposes. Often they're all rolled into the same day, because you would normally try to not only receive reports and sort out any problems and agree who's going to be doing what, but commonly this is all rolled into or focusing on applications for payment, so that at the time of dealing with applications, you can conduct a site visit, but that's not the site meeting. Perhaps I'm stating the obvious, but I think a very good tip is to make sure that formal minutes of meetings are issued. Site visits, in terms of inspections, in recording those is a completely different matter. So I found this, which I thought was great, from the RIBA in 1872. So this explained what the architect was expected to do under their principles to be observed in interpreting the scale of professional charges. So I've highlighted there that back then it was common for supervision and inspection to take place to ensure that the works are being executed. So that's the present tense, not the past tense. So in my mind, these are 2 very different things and come with very different duties, and definitely come with different degrees of risk. So it's more now about inspections rather than supervision. The difference really is that supervising work, if you can afford one, if the project can afford one, is probably done through a clerk of works, where they're very much monitoring the work as it's being done. The contract administrator doesn't do that. In the modern appointment documents, the contract administrator agrees to come along and inspect work during at particular times. And in this appointment document, you would set out how many times you're going to do that, and the fee per visit. Now, I'm not a big fan of this in particular because it isn't so much the number of visits. I think the important point is to identify when those visits are going to take place. So it might be that you want to inspect perhaps some complicated damp proofing in a basement, for example. Well, that might not coincide with the date of a monthly meeting for valuation purposes, that could happen in between quite easily. Well, that inspection is going to be absolutely key in terms of recording the state of that work and making sure that you're happy with it. So whilst the standard documents have got site inspections number, I think it's a good idea to identify particular stages when you're going to do it. So going back to the work stages on that plan of work, it now talks about inspections, not supervision. And it talks about inspections, not supervision as the work proceeds. This is an extract from a law report that I thought would nail the point really. This is a case from 2002. It's getting on for 20 years ago now. As I said, the older forms of contract require the architect to supervise. The more recent contracts requires the architect to visit the works and inspect the progress. And I've put in bold there, the judge said that it seems to me that inspection is a lesser responsibility than supervision. You bet it is. Another case, and again, I'll give you these slides afterwards if you haven't got time to take any screenshots or anything. I think this quite neatly summarizes the contract administrator's duties for inspection. The judge there said that in this case, by the way, the building contractor had gone bust, and so the employer was trying to recover in respect of defective work because they couldn't recover it from the contractor. So yeah, it's not enough to religiously carry them out. It's about when it's needed. That's important. One option is to instruct the contractor to not cover up particular work until it has been inspected. That's something that you could do in the specification or even as an amendment to the building contract itself. And you don't guarantee that you're going to spot everything. And as we have to explain to clients, just because there's a defect, it doesn't mean you've got a claim. So where there's a claim, there isn't always blame, I think is the point to take away from that. Some tips on site inspection: keep records, take photographs, videos. All the technology is available now. Be clear on your fees, what's included. Be clear on the scope of your service. You don't want to be using words like supervision unless you actually mean it. Yeah, got to keep away from words like that, and we want to be using inspection. And as I said, perhaps consider a contract amendment to identify, particular work that needs to be notified. We often get a question, well, it's not me, the building inspector came along and saw it. That's not going to help you if you haven't inspected the foundations adequately. This is a whole topic in itself, issuing certificates. So part of the role of the contract administrator is to issue a whole host of certificates. Got loads of them. So certificates of payment, completion certificates, possession certificates, practical completion, extension of time, non-completion certificates, making good of defect certificates, and then the final certificate itself. I haven't got time to go through everything, but the point I would make is that the role of the contract administrator is to deal with all these matters objectively and fairly, as was pointed out by the judge in that earlier judgment, because it's often a criticism that the contract administrator is being unfairly influenced by the employer. How common is that? You know, how many contract administrators feel pressurized into either issuing a certificate when they don't want to, or not issuing one when they want to, you know. Equally, do contract administrators get pressurized by contractors to issue certificates when the contract administrator really doesn't feel that it's appropriate? And again, on and I'm sorry about there's a lot of words here, but basically my view is that this is a good summary of what they've got to do. Got to act fairly impartially, and again, as I've said, in accordance with the in accordance with the contract. So there you go. Like I said, challenging. I think this is the most challenging part of the role. Right, I've got one tip I wanted just to touch on with payment certificates. Again, the topic of the payment cycle is a topic on its own. I think many of you will be familiar with the traps for the unwary when it comes to issuing payment certificates against applications. What if the payment certificate's late? What if the application's early? What if there's no payment certificate at all? What if the employer forgets or is late with a pay less notice? The consequences can be incredibly draconian in that if we get this wrong, a contractor can get themselves into an advantageous position where they can say that money is due for technical reasons, not necessarily because it reflects the value of the work done. So one thing I just wanted to point out, because I've come across this 3 or 4 times, is that the final date for payment of the certificate is 14 days from the due date. So under that contract I showed you, the due date is going to be a monthly date, which evolves from or is dependent upon the date of the monthly valuation. So the due date, I think, is 7 days after the valuation that comes in from the contractor, or the date in the contract that you agree is the valuation date. So the due date is going to be the start of all this. So your payment is within 14 days of the due date, where the payment certificate has got to be issued within 5 days of that due date. So the final date for payment isn't 14 days from the date of the certificate, it's 14 days from the due date, as earlier. That can catch you out, because the pay less notice, if your employer wants to withhold money, has got to be issued before the final date for payment. Well, if you've got that date wrong, then it's going to mean the pay less notice is going to be late and invalid. Something to watch out for. Another question that comes up is, what liability do we have for certification? Well, going back to 1901, the position was that the architects would often find that they would escape liability because they were felt to be acting as an arbitrator, and obviously arbitrators don't get sued, or not normally anyway. So it's very difficult to pin in a claim against an architect. That changed in 74. It's a bit like top trumps, isn't it? House of Lords came along and top trumped the Court of Appeal and said that James was wrongly decided, and there's nothing judicial about the function. And you can, what's wrong there? You can, architects, contract administrators can now be liable for performing those functions. It's all a bit reverse order on the slide for some reason. So I wanted to touch very quickly on the case that I did last year on D.R. Jones and Stepping Stone, local case held in Bristol over Zoom, which was a challenge. And the case is, you can read it online, you can search for that and find it. But the question was about retention. because there was no making good defect certificate had been issued. 8 or 9 years had passed because of ongoing wranglings over making good defects, and the question was whether the employer could still withhold the retention even though the relevant certificates hadn't been issued. Interestingly, there was very little law on that point, but I found it interesting because I've dealt with several cases where contractors have been trying to get retention, but the project team have long gone. There's been no certificates, no certificate of making good, and no final certificate. The answer, which was obviously the right answer, because it was my case, was that the retention did fall to be released, despite no certificate, but the employer would still get some money for defective works. In that case, it was 0 because the defects hadn't been properly proved as being liability for DR Jones. There were no cats on that Zoom trial, by the way, but one of the witnesses was caught on Zoom taking a telephone call, which was highly embarrassing, and you can read about that and what became of that in the judgment. Right, I'm just looking at the time because we're marching on. The other tip is to, and it's absolutely crucial, to make sure that you get your appointment documents. The RIPA offer a whole range of different appointment documents, depending on the type of contract that you're going to be administering. You know, everything's electronic these days, so I think we still need a signature. I don't see any harm in sending back a scanned copy, but from those of you that do act as contract administrators, I can't emphasize enough the importance of getting a signed document. Perhaps an email back saying they agree with it, perhaps that's good enough, but certainly something you would want to say that it's all agreed. Right, we've got a few minutes left. I wanted to talk try to touch on some topics on COVID. What a nightmare it's been, and it continues to be a nightmare. I can remember giving notice to my former firm about my new practice, and then came home and listened to Boris about the lockdown. So that was great. It's been very, very challenging, but fortunately, I set up the practice to operate on a paperless basis, not because of COVID, but because it seemed to me it was the way that we needed to go. And again, by complete coincidence, we've been looking at video conferencing. So when it came to do the trial in Bristol back in July, we were in a lucky position because we were set up for it. And I think COVID has made us all probably work in ways that we're probably going to come anyway, but it's just given it a push, isn't it? So the issues for contract administrators is what's the impact, under JCT? Does a contractor get extension of time? In other words, does the date for completion after which, if you're late, the employer would be entitled to liquidated damages, does that date get extended because of COVID? If the contract is delayed, does the contractor get more money? Time is money, isn't it? So if the contractor is going to be leaving things on hire for longer, scaffolding might be up, cabins could be on hire, do they get extra money for that? Should the employer think about suspending the work? What if it's a project where the employer has still got staff working there? It might be that the employer might need to close the site down because their staff are going to be working from home. I think the way this has gone very much is to keep things moving. I don't know how many of you are aware of the Construction Leadership Council's website, but very quickly, we had a procedure published for to promote and come up with some solutions for safe site procedures. Version 7 probably tells you now that there's been a lot to learn, and I think there's still a lot to learn about site practices. I think at the end of the day, it comes down to a personal choice of construction company owners, and obviously a personal choice for employers. The question is, how do we resolve those issues over time and money? Going back to the JCT contract very quickly, there's an obligation to notify the contract administrator if there's a delay, called relevant events in the contract. So what are the relevant events? Well, everyone was talking about force majeure, which I'll touch on in a second, but one relevant event is the government imposing any powers, so lockdowns and all that sort of stuff may well be relevant as a relevant event if you've got Boris telling everyone to stay at home. Force majeure is mentioned as a relevant event, and I'll come on to that in a second. The other section in the contract, which is buried at the end, so often gets overlooked, is that if practical completion, if before practical completion, the works are substantially suspended for a continuous period of the length stated in the contract particulars, and that's up to the parties to decide what that is, by reason of an impediment, prevention or default by the employer, contract administrator, the QS. I knew the QS had some role there somewhere. So it might be that the employers decided that it's too risky, they don't want the contractor on site. Just watch out for this, because this can lead to termination by the contractor if we don't have some form of agreement over how it's going to happen. Interestingly, I don't know who uses the minor works contract. The minor works contract is much less sophisticated, and you'll spot there that where delay occurs for reasons beyond the control of the contractor, well, that's really wide. Would that include COVID? I don't see why not. Force majeure is not defined in JCT. The principles are that it's got to be an event beyond the control of the parties. It's got to prevent you from fulfilling obligations, i.e. getting on with the work, permitting access. And the idea is that you can't do anything else to avoid the consequences. The view is that pandemics aren't automatically a force majeure event. I mean, we've got the guidance now on these site practices. So does it really mean the site comes to a grinding halt? Possibly not. So if possibly not, then probably not force majeure. This came up yesterday on Construction News. I don't know if any of you spotted this, but 1 in 3 contracts apparently aren't fit to address COVID. That's high. But does that mean that there's 1 in 3 contracts? Surely the parties can find a way to work their way through it. It doesn't mean it's going to be a dispute, although for a high percentage of those who've had experience with adjudication, perhaps so. But Turner & Townsend, their survey found that the liability, most liability, is going to be on the client side. Well, to mitigate that, you might want to define COVID-19 in future contracts. Might be helpful to provide a clause that says that if it's going to be suspended because of COVID, the contractor's still got to regularly update the parties, and we've got to decide who's going to allocate the risk. Yeah, so COVID's a big topic at the moment, but I don't see that many disputes over it genuinely on the ground. Most people are working together, working out a way of managing COVID to keep the project running. And that, of course, is what the contract administrator is there to help mediate over. So in summary, and I'm sorry I haven't covered every single role, it's important to recognize the role of the contract administrator is a mediator, very much so. Get the scope of services clearly identified. Select the right form of JCT contract. Do you want some amendments? The cynics say that amendments are there just to generate fees. I don't agree with that. I think, how can you possibly have one form of contract that's going to suit all different types of contracts and all different types of risks? So inevitably, I think amendments are necessary. In COVID-19, I think we're all working very hard to still get those projects completed, and that's very much where I come from when dealing with queries that are raised. So thanks for that. I don't know how much time I've got for some questions.
Thank you, Chris.
Yeah.
Thanks very much. Okay, ladies and gents, if you've got any questions, then if I could ask you to use Slido. I'm just looking at Slido now, Chris. A few of the comments actually were around the poll. People are saying that actually they took the poll last question to read had not gone to court. So I think maybe we misread that.
Okay.
at the centre.
Good. I'm pleased to hear that.
Yeah. Anyway, if I go to the last question on your list there, what can be dealt with by instructions and variations on one hand and full, it's moving around now, and full contract amendment on another?
What can be dealt with by instructions and variations on one hand and full contract amendments on the other? I'm not sure whether I completely understand that. So, well, what can be dealt with by instructions? So extra work is obviously the most common instruction. You can have instructions for opening up the work to inspect. I mean, you don't really want to do that, because the idea is that you've agreed what you need to inspect before you open it up, so you wouldn't want to have an instruction to have to open up something later on, but there you go. So amendments in terms of instructions, well, one of the amendments that we do see quite common is that if there's a variation, if there's going to be extra work, a common amendment is that the contractor has got to get those particulars, the amount of that extra work, the cost of that extra work, into the next monthly valuation. Yeah. And if they don't, then they've lost the right to claim that later on. The reason that's common is because the QS and the CA, for that matter, need to report to the employer on project monitoring of how the project's going in terms of the finances. So that's a very common amendment. Yeah.
Okay, I've got another question here. Is the high score on the last question a good thing if the conflicts and disputes are resolved on a project level rather than adjudication?
Well, if the idea was there's a lot of disputes, then that's obviously a bad thing. But as I mentioned, I've got a mediation practice, so if you've got good collaboration, you've got the right mindset of the parties that come into the contract at the beginning, with a contract administrator that's got a good relationship with the employer, most of these disputes are going to be mediated by the contract administrator. I actually see adjudication as a second tier of contract administration. Contract administrator can only take us so far, can't resolve it, so we then have adjudication.
This is all part of the culture change, Chris, isn't it? That many
Very
of us
much.
have been driving for 20 plus years.
Yeah.
I don't know about you, Chris, but I'm seeing at last that we may be getting a breakthrough in culture.
I think so. I want to deal with that question about mediation, if I may.
Okay.
Can we put that one up on the screen?
Yeah. Do you see mediation growing further as a dispute resolution process? Yeah.
Right. The answer to that is very firmly yes. The courts are encouraging mediation. If you refuse to go to mediation, you've got to explain to the judge why or why not. Yeah. If you've got a really bad answer, i.e., because I instructed Chris and we're about to win, that sort of answer, that's not a good answer. You know, the courts are expecting parties to mediate, and we do my practice does a lot of mediation. We've also dealt with mediations without party representatives. So the parties themselves have come along and said, look, we've got a dispute. Can we appoint a mediator? So we're doing mediations now through Zoom. Yeah.
Okay. So
which is great.
one more question then. What amendments are being made to new contracts made post-COVID? You talked about it briefly, but can you sort of enlarge on that?
Yeah, two things I see. The first one is that force majeure is now being defined. Yeah. Where it isn't before, but more commonly, we're finding that COVID-19 is appearing as a defined item. Yeah. So COVID-19 itself could be included as a relevant event. Yeah. And it gets more sophisticated because you could for example, cap the number of days lost to COVID. Yeah. You could agree who's going to bear the respective costs of site preliminaries. Also, you know, up to the parties to negotiate and then tell us how you want that reflected in the contract.
Okay.
Yeah, very, very common.
Thank you very much. Now, ladies and gents, just a couple of things I'd like to highlight. I'll ask that question in a minute. That's come in late. I just want to highlight a couple of things to make sure we get this message across. The first thing is we would appreciate, ladies and gents, if you'd use Slido to provide your feedback for today's webinar. The details are in the chat column, so if you could go to Slido and do that. Also, if you flick back through Slido, you'll see I've put details about CPD certification, which is now available. We've teamed up with an organization called MyPro Plus. So if you go to the MyPro Plus website and then you put in the reference code CE-312, that will enable you to download a CPD certificate to acknowledge your attendance today. So we're hoping that that's something which will add value to these webinars that we provide for you every week. We've got a few minutes left, Chris, so let's ask this question.
Yeah.
Under D&B, is it okay for an novated architect to carry out monthly inspections, final inspections for the employer?
Okay, so let me start by explaining what that means. A novated architect. So this would be where the employer, either the building owner or whoever's paying for the work, has already employed the architect to do some preliminary work. Yeah, probably to take it to planning. When the contractor comes along under design and build, remember that under design and build, the contractor, the employer doesn't design the final scheme. Yeah. So the question is, who does that? Well, commonly, the architect that was employed by the employer, yeah, is now going to be employed by the contractor. So actually, inspections are actually for the architect is going to be employed by the contractor if they've been novated. So the question is, well, I know I'm employed by the contractor, but can I carry out an inspection for the employer? Yeah. Well, I think in that situation, if this is an architect, you've got to be very, very careful, because if you're going to do some work for the the employer, you're going to have to make sure that you've got, I would expect, a new retainer, a new agreement between you and the employer in terms of what that actually covers. Do you see the point? Yeah. So the answer is, I don't see why not. But you'd have to be very, very, very clear on who your liability is to. Does that make sense? Does that answer it?
Thank you, Chris,
Yeah.
very much. I've just had a private question. Could I reiterate how to get the CPD certificates? So if you go to www.mypropass.co.uk, mypro, P-R-O, pass, B-A-P-A-S-S, all one word, .co.uk, and then the reference for today is CE-312. That will enable you to download a certificate. Okay, but the details are in the chat column. It's 1:01, Chris, so it's perfect timing. I'd firstly like to thank Howard and Abraham at Leaders Meets for hosting today. So thank you for that. Chris, thank you for giving of your time and your knowledge. Much appreciated. We really do appreciate that. Each week we try and bring you something very different. So next week we've got Simon Inkson as our guest. Simon works for Welsh Government, and they've got a very interesting scheme campaign whereby going forward, they've made the decision to build their affordable homes, 11 councils, in timber frame for sustainability reasons. And they've got a brand new project where they're asking the 11 councils to collaborate, work together. And they've asked 12 of my STA timber frame members to work together in collaboration. And this is going to be really interesting because in terms of collaborative working, for me, it's going to represent a real case study that others can use. And in particular, the method of procurement is being considered because for 11 councils to work collaboratively with 12 timber frame manufacturers without any main contractors in the middle, it's going to be really interesting to find out how that's going to work. So if you're interested in sustainability, if you're interested in procurement, please do tune in next week at 12 o'clock for Simon Inkson from Welsh Government. But for now, 1 o'clock. Don't forget to fill in the Slido form to tell us about the survey, your feedback for today. But it's 1 o'clock, just gone. Time for me to say goodbye and have a great weekend. Thank you very much, everyone. Thank you.
Thank you very much, Chris. Very interesting.
Was okay.
Yeah, that's fine.